Welcome back to Illinois Law, sponsored by the Illinois State Bar Association. And our topic tonight is personal injury matters from start to finish. I'm here with my guest, the Honorable Tom Lyons, Judge of the Circuit Court of Cook County, Ron Kalish, and Karen McNulty Enright. We were discussing about the process before a lawsuit is filed. Now, matters get to the stage where you got to file a lawsuit in the case, and where do you file a lawsuit here in Cook County?
At the Daly Center and any other branch court around Cook County. I think there's 5 or 6 different branch courts in addition to the main courthouse down. And
are those in the different suburbs?
Yes, they're sort of scattered around the outskirts of Cook County.
You file the lawsuit where the accident took place or where the parties live. So if everything happened in Cook County, you file in Cook County. But if everything happened in DuPage, or if the defendant resides in DuPage and the accident happened in DuPage, you have to file in DuPage. So there's certain requirements as to where you can file.
So you can't just pick Cook County or, unless you have those certain requirements.
Exactly.
Okay.
And once you file the case, you file it according to different divisions, depending on what you're claiming the case is worth.
And what are those 2 divisions that we have here?
Municipal division and the law division. The larger cases would be filed in the law division. The smaller ones would be handled in the municipal division.
And is there a difference in the process that goes about with the municipal division versus the law division?
Well, the municipal division, because they're smaller cases, they generally are handled more quickly.
Okay.
The trials are usually shorter, and in some of the divisions, you can, really in any division, you can represent yourself. But in the smaller division, municipal division, I think that the process is a little bit more flexible to allow people to do it themselves, more so than the law division.
And also they have some type of arbitration program that you have to go through in the municipal division first before you can get to the jury trials?
Yeah, in the municipal division, for the smaller size cases, before your case can go to trial, you first have to arbitrate your case. And what that means is there are lawyers who serve as arbitrators here in Cook County, and we sit and listen to a case, and it's a very informal process. It takes about an hour, and it's not in a courtroom, but it's in a conference room, and each side with their lawyers tells their version of the events, and a panel of usually 3 arbitrators make a finding, and that finding is not binding on anybody. Either side can decide to reject the arbitrator's award and have a jury trial. But if neither side rejects, then the case is over and the case settles, or for whatever the arbitration award was.
So the process in the municipal, because the case is a lesser value, streamlined a little bit more than maybe in a law division case over $50,000.
I think they move a little bit quicker.
And what happens when you file a case in the law division? From once you file the case, Judge, can you tell the viewers what's the process from the time they file it, from the court standpoint, until maybe before you settle it or get to a trial?
Sure. The case is filed, and then there's usually motions brought, sometimes, depending upon the nature of the claim, the cause of action. There's once all parties are served, there may be motions to dismiss brought for a variety of reasons. Sometimes it's the wrong party that's being sued, or sometimes it's a failure to state a claim, depending upon the nature of the case. Once you get all that established and the case starts moving, the parties will initiate. Usually they'll start with written discovery. First to look for documents and try and get all sorts of any documents they need. Very often there's protective orders to preserve evidence in a case. For instance, on a porch collapse case, you certainly don't want the landlord to go in and now take down the porch and repair it. You want to get an order to preserve it in the condition that it's in, so you can have experts or someone go out and inspect the premises. And then there's written discovery, where both sides will propound written questions to either side, and the parties will be required to answer those questions. And once they've completed that, and this is all closely supervised by the judge who's monitoring the case through a case management schedule, and depending upon the nature, the complexity of the case, and how the lawyers are working on it, the judge may think that it requires more intense case management in some cases than others.
What's a general period of time a case might take to get through this process of the discovery before you get to the trial?
Well, it'll take some period. It depends on the case. It depends on how many witnesses have to be, after written discovery is completed, It'll take a couple of years. I mean, a lot of times, I'm sure from the plaintiff's point of view, what's going on with my case, I haven't heard
Right.
anything from my lawyer. It's always smart for the lawyers to keep their clients informed, because it may not require their active involvement at one time, but it doesn't mean the lawyer's not working on it. The lawyers are busy propounding discovery, working things out with the other side, what they can agree on and what they don't, and then they have to schedule depositions or retain experts.
In Cook County, can somebody go look somewhere to see what their case is doing? Is there a place?
In Cook County, there are computers that are linked together, and everything that is filed in the Circuit Court of Cook County is scanned into the computer, and it's all done by either the plaintiff's name, the defense name, the defendant's name, or by case number. So they can look up what's going on the Circuit Court of Cook County website. They have the same thing for DuPage County and all the surrounding counties. So you can find out, when the lawyers go to court. And it gives you somewhat of an outline as to what's going on in court, but that doesn't necessarily mean that when the case is not in court that the lawyers aren't working on it.
I mean, a client could actually go look at their own case and kind of look at the sequence of what's going on, what's coming up next on the computer, any computer with Cook County Circuit Court.
Sure,
Correct.
that's all public access to anybody, really.
Okay, from the lawyer standpoint, during this time the judge talked about with this discovery going on and everything like that, what are the lawyers doing usually?
Well, we are finding out the facts of the case, and either through asking questions in writing, as Judge Lyons referred to, or taking what's called a deposition, which is really nothing more than asking a witness under oath with a court reporter present questions.
And why is this done? What's this discovery process done for?
Well, we're trying to continually find more information, and we also use that computer system to find out how many times someone's been sued. So if you have a slip and fall in a certain parking lot, you can also type in the address of the parking lot or the owner, and you can see on that same website we were talking about how many times that person's been sued. And then we try to look for other complaints. Did they have notice that this was a dangerous condition? Were they told to fix it by the village or the city and they never did? So we're constantly, as Ron said, getting information, finding witnesses, whether it's a car accident or premises liability, to try to prove our case, because ultimately we're going to be going in front of a jury and we're going to use all the facts that we can to help our client win.
So this discovery process, when it's all said and done, before the trial starts, it's accumulation of information, and what do you do with that then?
Yeah, the purpose of the discovery is to really sort of avoid surprise for both sides. By the time you get to trial, we pretty much know what everybody's is going to say in the case, and their versions are sort of set in stone. And so that it gives us an opportunity to evaluate both sides, to evaluate the case and decide whether the case is something that could possibly be settled or it's something that's going to go to trial. And it gives us the best information to give advice to our clients about what to do.
And when this discovery process is all done before the trial, is there something or anything the court does to try and resolve the case before it goes to trial?
Sure. Sometimes, in some cases, I think Ron said you kind of know what you have in front of you beforehand. In some cases, one of the parties may think it's appropriate to bring a motion to try and say, we don't disagree on very much here, and there's really nothing. That's the rare case where that's going to be successful, a motion of that nature, a motion for summary judgment, where there's no facts in dispute. So in most cases, there's going to be some facts that are in dispute. Usually the court will invite the parties to participate in a pretrial conference.
And what is that?
Hopefully the parties have on their own explored settlement, but very often it's helpful to have the assistance of the court, where the judge brings the parties in with both parties' consent. In some cases it's helpful to have the client there rather than the attorney communicating the position to the client. But and the judge will take a stab at trying to settle the case, and I think that's always a good idea for the parties to participate in that, because sometimes it's good to have a fresh look at the case and hear it from the judge's perspective of not only how potential rulings on pretrial motions may be ruled on, but also that could have an impact on the value of the case. And sometimes I think when I was a practicing attorney, sometimes it's good to have the client there to say, here's what the judge thinks of your case, and we look at it from one point of view, the other side looks at it from another point of view, and here's how the judge sees the case.
So sometimes you're independent, the client maybe will listen more to the judge and rely on that a
Yes.
little bit more. Help the attorneys resolve it.
Exactly, and some, I'm sure you've had experiences where maybe the lawyers all think that one of the clients being unreasonable, even their own attorney, but when it comes from a judge, sometimes the client seems to think.
Other than the pretrials or any other, we have a couple minutes left, maybe you can quickly tell the listeners or other methods to settle besides that.
Yeah, the judges are very busy and have busy dockets, and sometimes they don't have they only have a limited amount of time to devote to a case. So there are a lot of retired judges who are still very able and will sit and mediate a case.
And briefly, what is mediation?
A mediation is nothing more than two sides with usually a judge who has reviewed the case and comes with some information, sitting in a conference room. Usually you're split up into two different conference rooms, and that judge can go back and forth to these rooms and really just try and bring some common ground and try and settle the case. It's not binding on anybody. Sometimes it works, sometimes it doesn't work.
And the information is supplied by the attorneys to help the judge out about the case.
Each side will usually give what's called a mediation memo, and we provide that to the judge. And those things include, the facts of the case. What are our client's medical bills? How much are they expected to pay back? We'll include photographs of the injury. We'll include jury verdict searches as to what we think the case is worth based on other juries in the past. We provide that to the mediator. They review that before the parties come in. And a mediation could last one afternoon, or it could last a series of days, depending on the complexity of the case.
And if mediation doesn't work, we just have a minute left. What happens next?
Well, then there's a trial, and ultimately
Who's that before?
That's before a jury, and these are literally 12 people, so to speak, off the street, know nothing about your case, and they come and sit and listen to the story, listen to the witnesses, and at the end, they're the ones that go back in the jury room and deliberate and come up with a unanimous decision whether it's going to be a verdict, and if so, for how much, or if it's going to be a not guilty.
And after the verdict, the next thing you can do, if you're not happy with it, there may be an appeal.
There's usually a post-trial motion and then an appeal.
All right. Well, we run out of time. I'd like to thank my guests, the Honorable Judge Tom Lyons, Ron Kalish, and Karen McNulty-Enright for being here with us on Illinois Law, sponsored by the Illinois State Bar Association. And thank you for watching tonight's program. I'm Sam Kavathis, and I've been your host. Thanks, everybody.